Every year, losing parties from trials across the country hurl roughly 9,000 legal petitions at the United States Supreme Court. Out of that annual intake, the justices only accept and decide about 80 cases per term. This chart contrasts those 9,000 appeals against the final docket. It illustrates a rigorous reality, an acceptance rate of less than 1%. This rate exposes a common misunderstanding of the court's mandate. The justices operate beyond the scope of correcting individual lower court errors or fixing trials that feel unfair. To understand the court, we have to view it as a rigid triage architecture designed to filter out the overwhelming majority of its incoming workload. The court functions as a uniformity engine. Its mandate is to resolve disputes over the exact meaning of the U.S. Constitution and federal law, so that they are applied consistently across every state and territory. The core tool used to enforce this uniformity is judicial review. Utilized since the 1803 case Marbury v. Madison, it allows the court to examine and overturn government actions. This power gives the 9 justices the authority to strike down local, state, and national laws if they violate the Constitution. But the court is bound by a reactive constraint. Unlike high courts in some other countries, the justices cannot issue advisory opinions on confusing laws. They must wait for a trial to happen and for the losing party to appeal the case upward. Because the court must wait for cases to arrive, the act of curating the docket becomes a central pillar of its constitutional authority. This diagram shows the first barrier a case hits. The intake pipeline splits into original and appellate jurisdiction. Original jurisdiction bypasses lower courts, starting directly at the Supreme Court. The Constitution limits these to cases involving full representatives or where a state is a party. Many of these rare original cases involve 2 states fighting over resources, like the battle between Maryland and Virginia over oyster fishing rights, or the dispute between California and Arizona over the control of water flowing from the Colorado River. Despite the extensive geographic and economic scope of these state conflicts, original jurisdiction accounts for fewer than 1 case per year on average. Since original cases are a mathematical anomaly, over 99% of the court's workload is forced through the vastly more complex appellate pipeline. Cases flowing into the appellate pipeline come from 2 places: lower federal circuit courts of appeal or the highest state Supreme Courts. For cases arriving from the state level, there is a hard jurisdictional boundary. The court cannot rule on issues of state law. To survive this filter, a petitioner must prove their case involves a federal question, a specific claim under federal law or the U.S. Constitution. The 1963 case of Clarence Gideon shows exactly how a petitioner navigates this federal question filter from a state conviction. Appealing from a Florida state prison, Gideon bypassed the rejection pile by arguing the state denied his Sixth Amendment right to a lawyer. Over half of all cases appealed to the court each year come from people in prison, yet only a handful successfully frame a unique federal question that the court accepts. To survive the jurisdictional layer, a case must elevate itself from a localized grievance into a direct question about the national constitutional framework. For the surviving appeals, the formal intake mechanism begins when the losing party files a petition for a writ of certiorari. It is logistically impossible for 9 justices to physically read, analyze, and debate thousands of complex legal petitions every year. The first line of defense is the law clerks. These are typically top-tier law school graduates who previously clerked at a federal appeals court. To manage the workload, clerks combine forces in a cert pool, dividing up the mountain of reading. The clerks synthesize complex petitions into standardized summaries, providing the justices with explicit recommendations on whether each petition should be granted or denied. These clerks are instructed to avoid looking for bad decisions that should be overturned. They scan the petitions for specific flags requiring national resolution. The clerks operate as the central processing unit of the uniformity engine. They filter the noise so the justices only see cases demanding their attention. The most critical variable is a circuit split. This happens when lower courts answer the exact same federal question in 2 completely different ways. The second major variable is national impact. The court selects cases affecting the entire country. These often involve controversial social issues like privacy, abortion, or the death penalty. While social issues grab headlines, the court also takes on many business cases. These corporate disputes lack media attention, but dictate the flow of billions of dollars and affect millions of lives. There is also an external signal that influences the selection math: the Solicitor General. The Solicitor General is the primary official responsible for representing the federal government in court. The justices frequently ask the Solicitor General for their opinion. When the Solicitor General recommends taking a case, the probability of acceptance drastically increases. Petitions move forward when they trigger specific economic, political, or systemic variables that require the court's intervention, regardless of the individual petitioner's desire for justice. The final stage of the filter is a private conference where the justices review the clerk summaries and debate the surviving petitions. To officially move a case onto the docket, the court relies on an unwritten mechanical threshold known as the Rule of 4. Unlike standard democratic voting, a simple majority of 5 is not required to grant a writ of certiorari. This rule allows a minority of just 4 justices to force the entire court to hear a controversial issue. Once those 4 votes are secured, the petition survives the gauntlet. It transforms from a long-shot request into an actively scheduled Supreme Court argument. Despite these layers of review, the math remains. Over 99% of petitions fail to secure 4 votes and are denied. The immediate legal consequence of a denied petition is absolute. The decision of the lower court stands permanently for that specific trial. It is important to note that a denial is not a signal that the Supreme Court agrees with the lower court's ruling. A denial simply means the case failed to meet the requirements for resolving a national legal conflict. The Supreme Court serves as the final, highly filtered editor of the national rulebook.